This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law's Intellectual Property Review. I'm Josh Block. Albums like Bruce Springsteen's Darkness on the Edge of Town, Billy Joel's 52nd Street, and Funkadelic's One Nation Under a Groove will all soon turn 35, and that birthday will trigger a section of the Copyright Act that has record companies preparing for a copyright battle. Coming up, we'll explore what's happening and what is likely to happen as musicians begin to try to exercise their termination rights. I'm joined now by Laura Mcquaid, a writer and editor of Bloomberg Law's Intellectual Property Law Report. In 2013, this section of the Copyright Act will take effect. Bruce Springsteen, Bob Dylan, Kenny Rogers, the Eagles, Billy Joel, and many others will have termination rights available to them. Laura, what is the termination rights provision in the Copyright Act of 1976?
In a nutshell, this provision gives authors the right to terminate and therefore reclaim a prior transfer of copyright in their works. This issue has received a lot of attention in the popular media lately because of the impact it will have on the music industry and the fact that it involves such popular artists like those that you mentioned. In the legislative history for Section 203, the stated reason for this provision is to address quote, the unequal bargaining position of authors resulting in part from the impossibility of determining a work's value until it has been exploited.
Not all of these artists at that time were, some were famous, some had bargaining power, some didn't. It doesn't really...
Yeah, I think just the sense is that the way that the industry works when it comes to any of these creative industries, some people are going to turn out to be Bruce Springsteen and others aren't, and I guess Congress just wanted to address this issue that there was really no way to tell just how valuable a work could end up to become until the artist had the resources that were available to them by signing with these record companies. And so it was just a way that was negotiated as part of the Copyright Act of 1976 to kind of address this unequal state of things. So
what does it take to qualify?
Section 203 applies to transfers of copyright that were executed on or after January 1, 1978. And the right to terminate the transfer for these works accrues 35 years later. So termination rights for works transferred in 1978, therefore, will mature in 2013. That's why this issue has started getting so much attention now, because we're really coming right on the cusp of some of these termination rights accruing.
And have artists already begun indicating and following procedures to exercise their termination rights?
You'd have to search the Copyright Office records work by work for a definitive answer on that, but I've seen reports that musicians such as Tom Petty, Bob Dylan, Bryan Adams, and Tom Waits have already done so.
And what are the procedures that the author or artist has to follow?
Basically, it involves serving a notice of termination, which has very specific requirements of what needs to be in the notice. You serve it on the current copyright owners, and then that notice also has to be recorded with the Copyright Office. This section also sets forth when the termination goes into effect, which is at any time during a period of 5 years, beginning at the end of 35 years from the date of execution. It's different if the grant covers the right of publication of the work. Again, you can just refer to the section for the particulars of that. And it also provides when the termination notice is served, which is not less than 2 or more than 10 years before that date. So that means that notice of termination under this section could be served at the earliest 25 years after the execution of the transfer, so they could have been served as early as January 1, 2003.
With the rise of the internet and digital, record company music sales have taken hits in recent years. Do you have a sense of where the industry is as far as termination rights and whether they can sustain another hit and how this will affect business?
Well, yeah, that really is the question, and it's hard to say. Most of the data shows that the industry has taken a severe hit in the last 10 years. And there's numerous reasons cited for that: music piracy on the internet, the increase in digital sales of singles as opposed to albums. But interestingly, there has been some recent data released that shows that numbers were improving in the first half of 2011.
How do you expect the record industry to respond to artists claiming termination rights?
I expect that they will fight tooth and nail for every copyright that they can, and in particular for some of the more profitable albums from their back catalogs, like from the artists that we've mentioned. But of course, litigation does not have to happen. The labels and the musicians are free to negotiate new terms for their relationship, and that is part of what this section was meant to do, to give artists a second bite at the apple, so to speak, or a second opportunity to negotiate the terms now that everyone understands what the worth of their work.
Was this part of the section just to apply to music?
No, it certainly applies to other industries. It is definitely not limited to just music.
Now, how can record companies fight this? What legal theories will they try to use?
Theories that I most expect to see are the argument of that the works were works made for hire, and also I also expect to see them try to challenge the issue of authorship. In other words, as the Section 203 applies, if the work was a work of joint authorship, then a majority of the authors that executed the grant have to participate in the notice of termination. So those are two ways that I expect to see a lot of challenges.
There's a current case that is working its way through the system that will test these theories. We can probably use it to explain how they'll be applied. Tell me the facts of the Village People Scorpio Music versus Victor Willis case.
Sure. So in this case, Victor Willis, who was one of the singers in the Village People, served a notice of termination on the record companies who currently own the rights to these works. The Village People, of course, are famous for their hit YMCA, as well as a lot of other songs, but YMCA in particular is apparently a very lucrative song for the current owners. I saw in one article that it generates an enormous amount of money in royalties. So Victor Willis served a notice of termination on the record companies, the current owners, noting YMCA as well as 30 some odd other songs that he was also claims to have been the author of. So the record companies filed an action for declaratory judgment that the notice of termination was void. And their two primary arguments that they state are the ones that I mentioned before, one arguing that the works at issue were works made for hire, and therefore Section 203 should not apply, and he didn't have termination rights for them. And the other argument that they're making is that they were works of joint authorship, and that he did not have the right, therefore, to effect the termination on his own. One of the interesting things I've seen in an article I read was a quote from the attorneys for the record companies, where they explain that in support of their work for hire argument, that the Village People were really a creation of the record companies. They were sort of like the boy band concept, where they were put together. They were not a band that was sort of organically existed or joined together and shopped around their music to record companies, and they think that this fact really will support their argument that they were that the songs that they ended up creating were works made for hire.
And one might think that given the legislation's intent to protect the artist with unfavorable bargaining power, that work for hire and joint authorship, these concepts, these legal theories have been around a long time, that they might have been somehow incorporated or thought about when the law was passed. Do you have any sense of is there anything out there already about this and how that might be viewed?
The provision itself is very clear. Works for hire are not eligible for termination rights. And work for hire, the work for hire doctrine is a very fact-specific issue, and so courts have to do this analysis. And regardless of whether it's fair, record companies are free to argue that it was a work made for hire. And even if, and we don't know whether this is true in the Village People case or not at this point, because there's only a complaint in this case, filed in this case, whether or not there is a work for hire provision in a contract, that doesn't make it a work for hire. A court is still going to engage in the analysis to see, in fact, whether it is truly a work made for hire.
So will the resolution of these issues in this case impact future termination rights cases?
They will impact it, and certainly people will be watching with great interest. But again, since these are such highly fact-specific determinations, it's hard to say whether any early decisions involving termination rights will offer any clarity. So we'll have to see.
What is the status of Village People case?
From what I can tell from the docket, there's only been a complaint filed. So I imagine at this point it is they're just beginning the early stages of discovery.
Now, in your article, I read about the Register of Copyrights and her how she testified before a subcommittee on the judiciary, and she sort of put forth an interesting scenario. What did she say?
Well, I mean, if you're talking about the joint authorship issue.
Yes, correct. Yeah, and I guess it's specific to that joint authorship issue.
Yeah. Well, she sets forth a hypothetical where you could have a sound recording where there might, for example, be a music producer that was involved in the case as well, and this music producer may have transferred any copyright that he held in a sound recording pursuant to a separate written document than the artists even did. And if you look at the language of Section 203, it refers to joint authorship with respect to a single execution of copyright. And so therefore, you need a majority of the joint authors with respect to any one particular transfer. So therefore, if you have transfers that were granted pursuant to separate executed documents, you could end up with a very complicated situation where the author, with respect to a work that executed one document, may want to effect termination of the rights, whereas an author, a joint author that had signed a separate agreement may not. So you can see where that could result in some complicated situations, and I believe that the Register of Copyright said that it could theoretically result in separate distributions of the same work.
So it seems like, at least with the joint authorship, there's almost a continuum. You have a singer-songwriter on one side, and maybe songwriters that work together, and then a concept group like the Monkees or the Village People on the other, and somewhere all the way at the other end.
Mm-hmm.
Yeah,
and that, of course, that goes along with the work for hire argument, because some of the under work for hire doctrine looks at, in the Copyright Act, it's defined as a work that's prepared by an employee within the scope of his or her employment, or a commissioned work which the parties expressly agree in a written instrument will be considered work for hire. But how this is played out in the courts, different courts have set out different factors, non-exclusive factors that they look to determine whether a particular employment relationship and whether the resulting work fits into one of these categories. And so, again, a very fact-specific analysis that applies to the circumstances of each particular case.
That's Laura Mcquaid. You can read the Law Report article about termination rights, along with the complaint and other court filings in the Village People case, at BloombergLaw.com. You can find new IP podcasts every Tuesday at YouTube.com/BloombergLaw, iTunes, and on the Bloomberg and Bloomberg Law websites. Thanks for listening.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.